mandatory term of imprisonment for life without parole, or an indeterminate term of not less than 25 years, that may be for life.
Okay, but I want the death penalty.
Enhancement in violation of Utah Code Annotated 76-3-203.14 sub 2. Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson's belief or perception regarding Charlie Kirk's political
He's in a
expression.
turtle suit.
Notice, if the trier of fact finds beyond a reasonable doubt that the victim targeting enhancement applies, the sentencing judge or the Board of Pardons and Parole shall consider the defendant's selection of the victim as an aggravating factor. Violent offense committed in the presence of a child aggravating factor, the sentencing judge or the Board of Pardons and Parole shall consider as an aggravating factor in their deliberations that the defendant committed a violent criminal offense in the presence of a child. Count 2, felony discharge of a firearm causing serious bodily injury, a first-degree felony, in violation of Utah Code Annotated 76-11-210 sub 2 and 3C, in that on September 10th, 2025 in Utah County, the defendant Tyler James Robinson discharged a firearm in the direction of Charlie Kirk, knowing or having reason to believe that Charlie Kirk may be endangered by the discharge of the firearm, and that
he is sitting creepily still, man.
To Charlie Kirk. Victim targeting enhancement in violation of Utah Code Annotated 76-3-203.14 sub 2. Tyler James Robinson intentionally selected Charlie Kirk.
Oh, there we go. He blinked.
Because Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression. Notice, if the trier of fact finds beyond a reasonable doubt that the victim targeting enhancement applies, the sentencing judge or the Board of Pardons and Parole shall consider the defendant's selection of the victim as an aggravating factor. Violent offense committed in the presence of a child aggravating factor.
Damn, that was a juicy
one.
The
sentencing judge or the Board of Pardons and Parole shall consider an aggravating factor in their deliberations that the defendant committed a violent offense in the presence of a child. Count 3, obstruction of justice, a second-degree felony in violation of Utah Code Annotated 76-8-306 sub 2, in that on September 10th, 2025 in Utah County, the defendant Tyler James Robinson, with intent to hinder, delay, or prevent the investigation, apprehension, prosecution, conviction, or pursuant to any person regarding conduct that constitutes a criminal offense, conceal or remove the firearm used to shoot Charlie Kirk, and the conduct that constitutes an offense would be a capital felony or a first-degree felony. Count 4, obstruction of justice, a second-degree felony in violation of Utah Code 76-8-306 sub 2, in that on or about September 11th, 2025 in Utah County, the defendant, Tyler James Robinson, with an intent to hinder, delay, or prevent the investigation, apprehension, prosecution, conviction, or punishment of any person regarding conduct that constitutes a criminal offense, destroyed, concealed, or removed the clothing he wore during the shooting, and the conduct that constitutes an offense would be a capital felony or first-degree felony. Count 5, tampering with a witness, a third-degree felony.
Dude, is sitting psychotically still. It reminds me of Brian Koberger, actually.
76-8-508, in that on or about September 10th, 2025 in Utah County, the defendant, Tyler James Robinson, believed that an official proceeding or investigation was pending or about to be instituted, or intended to prevent an official proceeding or investigation, and attempted to induce or otherwise cause his roommate to withhold testimony, information, a document, or an item, to wit, directing his roommate to delete incriminating text messages. Count 6, tampering with a witness, a third-degree felony, in violation of Utah Code Annotated 76-8-508, in that on or about September 11th, 2025 in Utah County, the defendant, Tyler James Robinson, believed that an official proceeding or investigation was pending or about to be instituted, or intended to prevent an official proceeding or investigation, and attempted to induce or otherwise cause his roommate to withhold testimony or information, to wit, directing his roommate to stay silent.
I can't wait till they drop names of everybody who knew about this ahead of time, man.
Count 7, violent offense committed in the presence of a child, a Class A misdemeanor in violation of Utah Code Annotated 76-3-203.10 sub 2 and 76-3-203.14 sub 3a little double I. In that on or about September 10th, 2025 in Utah County, the defendant,
the discovery
Tyler
portion.
James
Oh, it's going to be
Robinson,
so good.
Committed criminal homicide in the physical presence of a child
Is this
younger
live stream?
than
Yeah, this is
14
live
years
right
of
now.
age, with knowledge that a child was present and that may have been seen or heard the commission of the criminal homicide, victim targeting enhancement in violation of Utah Code Annotated 76-3-203.14 sub 2, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression. That concludes reading of the information. Mr. Robinson, this case is set for September 29th at 10 a.m. It will be a waiver hearing, and I will be the judge assigned to this case. Mr. Robinson, I invite you to join us at that time. Is there anything further, counsel?
No, Your Honor, we'll have counsel appointed by then. Thank you.
Mr. Gurander, anything further?
One item, just for clarification, Your Honor, the hearing on the 29th, is that in person or WebEx?
Thank you. That is a great question. It will be via WebEx.
WebEx.
Okay. Thank you.
They're pushing fast. Good. They should be.
I want to thank all parties for being here, and this concludes this hearing at this time. Court is in recess.
All right.
Okay, bye. Just reading out all of the things they're charging him with, which we saw the Utah guy mention earlier. They are going to be, I opened it like a minute or two late. They are going to be seeking the death penalty, and hopefully the death penalty actually goes through. I don't want to see tax dollars keeping this fucking thing alive in prison for years. Luigi update. Die-hard Luigi Mangione fans camp outside of New York City court. They hoot and holler, celebrating the tossed terror charges. They're fanning the flames. Die-hard fans of Luigi Manicotti ghoulishly hooped and hollered in celebration outside of Manhattan Courthouse Tuesday as the accused CEO assassin's terrorism charges were dropped. Many fanatics had camped out all night to see Mangione and held up homemade signs intermingling beefcake-like images of the twisted folk hero with political and anti-health insurance company messages. Oh man, I hate health insurance companies as much as the next guy, but like, I'm not gonna celebrate the death of an employee. That's a little weird. That's a little fucking ghoulish, man. Free Luigi, one protester who wore a green hat like the Luigi video game character shouted in a call-and-response chant. The carnivalesque celebration unfolded against the backdrop of conservative influencer Charlie Kirk's assassination last week, putting a spotlight on U.S. political violence. Mangione had already attracted a warped following among many leftists who flocked, often clad in costumes, to his past court hearings. After he allegedly murdered United Healthcare CEO Brian Thompson in December, their poisonous political pageantry continued as Mangione was carted into a Manhattan Supreme Court hearing, where a judge was expected to debate whether jurors could see his diary. Why would you not allow people to read his diary? That's weird. That woman's face is more plastic than flesh. Holy shit. That seems to be pretty common nowadays. Jesus Christ, these people are grotesque. And it's interesting that, like, you can look in their eyes and they just look dead. They just look like completely dead eyes. Mangione, 27, wants to block prosecutors from bringing up his notebook where he purportedly mused about killing the greedy CEO to draw attention to an industry that extracts human life force for money, when he goes on trial for the December 4th, 2024 assassination in Midtown. So that seems like it would be evidence. Why would we be allowed to exclude that? Why would they be allowed to exclude something where he muses about killing the CEO that he then went on to kill? Maybe I just don't understand, like, the legal system because I'm not a lawyer, but to me that just does not make any fucking sense. Why would they not admit that? Cops in Altoona, Pennsylvania discovered the red notebook, a partially 3D printed pistol, zip ties, and rolls of duct tape inside the privileged anti-capitalist backpack when he was nabbed after a 5-day manhunt. The suspect's lawyers have lobbied to suppress the contents of the bag from being shown at trial, arguing that the Pennsylvania cops breached Mangione's constitutional rights by searching him before getting a warrant. But the Manhattan DA's office says it has the right to show jurors the screeds of a man they accuse of carrying out the twisted act of terrorism by executing the father of two on the day of United Healthcare's investor conference. In an October 22nd entry, Mangione, who grew up in a wealthy, well-known Baltimore family, allegedly fantasized about the news coverage that such a murder would receive. The point is made in the news headline, Insurance CEO Killed at Annual Investors Conference. The University of Pennsylvania grad allegedly wrote, "It conveys a greedy bastard that had it coming." Manhattan Supreme Court Judge Gregory Caro punted on a decision over the diary, but he dismissed the terrorism charges against Mangione in a victory for his defense. Caro also rejected Mangione's motion to pause the state case while he goes to trial in a separate federal murder case that carries a possible death penalty. The mixed bag for Mangione didn't appear to matter for his fans, who didn't bring their circus inside the courtroom. What? They cheered the top charges being dropped while holding signs such as "Wealth comes first" and "Lock up the real criminals," which featured photos of President Trump and Mayor Eric Adams. One woman named Jasmine, who also wore a Luigi video game character hat, showed off a backpack with Mangione's image etched in lights. Another flower garland woman wore a pink shirt with Mangione's face inside a heart, with Italian boys emblazoned below. I love Italian men as well, but not fucking this one, man. What the hell? These people are wild. Mangione has pleaded not guilty. Mangione's remaining charge of second-degree murder means he's still charged with intentionally killing Thompson, a father of two, just not as an act of terrorism. It very much reads that that is what it is. I don't understand these people. He's due back in court on December 1st. But that is our unfortunate Luigi Manicotti update. Very, very unfortunate update. I hate to read it. It kind of sucks. They all have families. Landscaping company says ICE/FBI took 3 employees into custody. And without reading a single step further, I hope that the landscaping company faces fines so fucking large that they go out of business. They willingly hired illegals. I don't want to hear their fucking crocodile tears. The co-owner of Lasana Landscaping in Marblehead says ICE and the FBI took 3 of their landscapers into custody on Beach Street Friday morning. They all have families, Allie Williams told The Current on Monday. They've been with us for a while, 2 for over 3 years, and the other one new this year. Why are you just admitting to the length of your crimes, you dumb fucking woman? All very reliable, hard-working, good people who care about the quality of work that they do. They can get deported with their families. Their families can be deported with them. We're not going to break up the families. We'll keep them together. The family that gets deported together stays together. You know, that's what I say. Williams said she had gotten no information about the men's whereabouts. I know the families are working with their lawyers on getting the men released. Who are paying for those lawyers? How can they afford that? That's, I imagine that's pretty expensive. I'm sure some lawyers will do it pro bono because they want to keep illegals in this country for some reason, but like, I wish I could give you more information, but we have not been given any ourselves, she said. On Friday's scene, resident Sarah Fox said she was walking down Beach Street when several vehicles hemmed in a Lasana landscaping truck, and men wearing FBI and police gear started screaming at the driver. Fox said she heard one agent yell, "Your identification is fake." James Covington with Boston's ICE office confirmed to The Current that it was a targeted enforcement operation by ICE. Targeted enforcement operation. So not only was this landscaping company knowingly employing illegals, but one of the illegals was literally a target. They knew him beforehand. I wonder why they were targeting this guy specifically. It was in support of Operation Patriot, Covington said. A targeted enforcement operation means we were going after someone specific. He had not provided any other details by Monday at 2 p.m. Marblehead Police Chief Dennis King said, "We were not notified nor asked to assist, but are aware of the reports of the activity." Yeah, considering how much Boston has tried to hamper ICE going in and cleaning up the place, it makes perfect sense to me that ICE would not notify this local police department either. Because that local police department might do the same thing and be like, "Oh, ICE is going to be in this area. you know? This is horrible, Fox said. This man didn't do anything wrong. He was on his way to work, going to make our lives easier. But who will cut our grass and clean our toilets if you deport all the illegals? That fucking white women strike again, bro. Holy shit. Now his life has changed forever. Who is going to pick up his kids after school today? Hopefully also ICE, so that they can be deported as a family. A local GoFundMe has raised more than $3,800 as of Monday to help the families of the landscaper with legal expenses. Dozens of people donated. Why is there a GoFundMe to help keep someone in this country illegally here? Like, I just do not understand these people. That fucking heat map, man. Immigration attorney Diane Slavitt-Baylis, who lives in Marblehead, was surprised by the action Friday morning. Obviously, this was an ambush, and the people in the Lasana truck didn't know their rights, and this is what ICE is counting on, Slavitt-Baylis said. To come into a suburb, it's not to fight crime, it's just to pick up people who are not expecting it. What a dumb fucking thing to say. These illegals are doing landscaping in a suburb, therefore they're not doing anything wrong. What the fuck, brother? What the fuck? Slavitt-Baylis advises her clients that if they are pulled over by ICE or other federal agents, to roll down their window and keep their hands on the steering wheel. Drivers are required to provide a name and address, but they are not required to say anything more. Imagine helping illegals. I'm all for informing people of their rights, but they're here illegally. Essentially, they have none. According to its website, Lasana Landscaping was launched in 2002 by Williams and her husband, Lasana Diawara, who first met in a small farming village along the Niger River in Mali, West Africa, where Diawara was farming rice on his family's land, and Williams was working as an agricultural Peace Corps volunteer. If I were to write a story with a white woman character that had both of the background and the political beliefs of this Allie Williams lady, I would be told to rewrite the character because it's just too, like, unbelievable, right? Like, it's not, this isn't a real person. This is a green card wedding. In 2001, they moved back to Williams' hometown of Marblehead, where Diawara worked for a couple of years at Kip's greenhouses and met some of his first landscaping customers. Congressman Seth Moulton, who grew up in Marblehead, slammed the ICE action. There's not a single American mentioned in this story, including all of the actual Americans by birth defending this. Armed agents and unmarked cars surrounding a local landscaping truck and screaming at the driver in front of neighbors without even notifying Marblehead police or the district attorney is not law enforcement, it's intimidation. No, it's getting shit done. It's abiding by our laws. If they're here illegally, they need to leave. They can go home. Moulton continued, these tactics do nothing to protect our communities. They do everything to protect our communities. What the fuck do you mean? Oh no, you might have to find another landscaper to cut your grass. Maybe hire someone who's not illegal. You fucking freaks. They only terrorize them. People should not have to fear being caught in the middle of an ICE operation on their way to work or school. Yes, they should. If they are here illegally, they should feel that fear until they are rounded up and kicked the fuck out. What do you mean by this? When residents are afraid of their own government, they're less likely to cooperate with law enforcement, and that makes everyone less safe. If you're here illegally, my government is not your government, and that's why you're being kicked out. State Rep Jennifer Armini said, it's shocking and distressing to see federal agents in Marblehead. Landscapers are not criminals. Well, they're here illegally, so yes, they are. They are part of our economy and, by extension, our community. The goal of today's actions is not to keep us safe. That's the big lie. Its goal is to destabilize our communities and terrorize individuals and their families. Marblehead has never given in to tyrants, and we're not about to start now. These people are insane to me. I don't understand. How do you get this way? How do you get this way where you're just like, I need my slave labor. I gotta pay the $50 for my landscaping instead of the $110 that I would pay an American. I was like, Jesus Christ. More South Floridians accused in fake nursing diploma scam, feds say. Wow, doesn't that make you feel great? If you go to get treatment, either your nurse doesn't have a real diploma and doesn't know what the fuck she's doing. She might be a DEI diploma if she's not a fake diploma, or she could just be one of those people that thinks you should die because you're a milquetoast Republican. Like, damn, you're gonna get fucked 7 ways from Sunday. What's even the point of going anymore? That's what I say. I fucking hate doctors. It didn't take this to radicalize me against doctors. I already hated them. 12 more people, including 8 South Floridians, were charged for their roles in a scheme that sold thousands of fake diplomas to aspiring nurses across the country, nearly 3 years after federal authorities first announced charges against others. Then U.S. Attorney for the Southern District of Florida, Mackenzie LaPointe, announced in January 2023 that more than 7,000 people purchased fraudulent nursing diplomas and transcripts from for-profit nursing schools in Florida, including Siena College in Lauderhill, Sacred Heart International Institute in Fort Lauderdale, and Palm Beach School of Nursing in Palm Beach County. The aspiring nurses who purchased fake credentials used them to qualify for national exams, allowing those who passed to become eligible for licenses and to be employed in nursing jobs despite never having taken the required courses and clinicals. Diplomas on average were sold for $15,000, the scheme garnering a total of about $114 million. No, even if they passed the, exam, I wouldn't trust them, because you know who else passed an exam for a license? That fucking Indian guy who killed a family because he took a U-turn that he shouldn't have because he can't read signs. We found out that there was mass cheating in all of those licensing exams, so how do we know that's not going on here too? In phase 1 of the investigation in 2023, 30 people, including at least 8 South Florida residents, were charged and convicted by entering a plea or at trial. As of Monday, some of the additional 12 cases have been scheduled for sentencing or trial, while one person has been sentenced to 13 months in federal prison, federal prosecutors said in a news release. Among the South Florida residents whose cases were announced Monday are Carlene Norius, 51, of Broward County, who is the president of Carlene Home Health School, Incorporated, in Plantation and vice president of Carlene Home Health School 2, Incorporated, and in West Palm Beach. Her trial is set to begin December 1st. Patrick Buchanan, 40, of Broward County, who is the owner, registered agent, and manager of Sigma Institute of Health Careers, Incorporated, in Lauderhill. He pleaded guilty to conspiracy to commit wire fraud and will be sentenced November 19th. Gilbert Hippolyte, 73, of Palm Beach County, who is the owner of Techni Pro Institute, LLC, in Boca Raton. He is charged with conspiracy to commit wire fraud. Irene Matthews, 55, of Palm Beach County, who is the registered agent of Agape Academy. Really? People fell for that? Of Sciences, LLC, in Delray Beach. She is charged with conspiracy to commit wire fraud. Lemuel Pierre, 56, of Broward County, who is the owner of MedLife Enterprise, Inc. in Lauderdale Lakes. He's charged with a conspiracy to commit wire fraud. Joel Lubin, 51, of Miami-Dade County, who is the registered agent and administrator of Ideal Professional Institute in Miami Gardens. He is charged with a conspiracy to commit wire fraud. Jose Napoleon, 40, of Palm Beach County, who is the director of admissions for Azure College in Fort Lauderdale. He is charged with conspiracy to commit wire fraud. Victor Escalante Zerpa, 68, of Miami-Dade County, who incorporated Academus University Corporation in Coral Gables. He is charged with conspiracy to commit wire fraud. And Stephanie Dorsica, 57, of Broward County, was the head of nursing at Techni Pro Institute, and she's charged with conspiracy to commit wire fraud. Why are they all so old? The youngest person here is 40, and it goes all the way up to 73. What the fuck? Still cooking at 68. Yeah, right? About 2,400 of the more than 7,000 students who purchased the fake credentials eventually passed their licensing exams, mainly in New York. Wow, I'm shocked. The corruption in New York. And once again, how do we know that they passed them legitimately when we know that there's mass cheating on CDL exams? Nurses certified in New York are allowed to practice in Florida and many other states. Those who purchased the documents were not likely to be criminally charged, federal officials said in 2023 when charges were announced. I would say that, the only thing to do about this is if someone presents you with credentials from one of these fake academies, regardless of whether they pass a licensing exam or not, it is your duty as an institution to not hire them. Nintendo finally wises up to Palworld, announces Pokemon crafting and building game Pokopia, starring a Ditto that thinks it's a real human. I really would love to be excited for something like this, but it took Palworld existing to get Game Freak off their asses and actually make something decent Pokemon related. If this is by Game Freak, it could just be the Pokemon Company and somebody else for all I know. So let me say maybe not Game Freak, but the Pokemon Company in general. And it took them waging like crazy fucking patent filings to try and kneecap not just Palworld, but any other game that decides to use ball catching mechanics or like creature summoning mechanics. Nintendo has gone absolutely fucking insane with power. And it's unacceptable. And like, I would love to enjoy Pokemon game that sounds fun, but I can't, knowing how like shitty they have been the past few years. Pokemon Pokopia blends the best of Stardew Valley and Minecraft in this new cozy game that sees you building a lovely patch of heaven for your Pokemon pals. The twist is you're a Ditto that's transformed to look like a human. Revealed today during the Nintendo Direct, Pokemon Pokopia is launching on the Switch 2 next year, 2026. It's basically Pokemon's answer to Palworld. Unlike most survival and farming games where you need tools to progress, in Pokopia, Ditto can find wild Pokemon and learn their moves to help with construction. Bulbasaur's leafage will transform your arms into vines so you can plant grass, and Squirtle's water gun has Ditto spitting the wet stuff out of its mouth to keep crops from getting too thirsty. It's just like body horror, man. Scyther's moves help you cut down trees for wood, and Hitmonchans let you punch through rocks for rock. Use these resources to build homes for your mons and terraform the landscape around you, just like in Minecraft. Pokopia even has a similarly blocky aesthetic. The trailer shows a fair few Pokemon, including fan favorite Pikachu, its unevolved form Pichu, and a Pidgey. There's also a cute sleepy Swablu and several other mons. The wild Pokemon seem to appear from tall grass, so I imagine exploration will play a key role in the upcoming game. Although the trailer only shows one small patch of land that slowly gets turned into a cute, cozy base. I haven't watched the trailer, nor do I particularly care to, but this article kind of goes hand in hand with this other article I have. The patent office made a huge mistake how Nintendo's problematic summoning patent passed without scrutiny. When I first mentioned this, it was just that they had filed for one, not that it had passed. Apparently it has passed at this point. Apparently. The controversial summoning a character patent acquired by Nintendo has caused uproar, and here's why it was allowed to happen. Earlier this week, with the help of a fantastic report from GamesFray, we covered the news of Nintendo securing a new US patent that not only looks like part of their arsenal against Pocket Pair's Palworld, but could also send shockwaves across the wider gaming industry. I'm of course talking about the patent for summoning other characters to fight for you in the game, otherwise known as patent number 12,403,397. I've been following the back and forth between Nintendo and Pocket Pair since the original lawsuit in Japan, and I don't think I've ever seen this much attention on a Nintendo patent filing, and with good reason. It's insanely broad, and it's certainly not something Nintendo invented. Most people are baffled at how the US Patent and Trademark Office granted it in the first place. Thankfully, amid all the uproar, Florian Mueller, the patent and gaming litigation expert behind GamesFray, sat down for a podcast with Fratanga Plays to break down exactly how Nintendo managed to push this patent through the USPTO. His take on the documents and the tactics involved is a fascinating listen. I highly recommend checking out the full episode, but for now I've pulled together the juiciest highlights below. In the interview, Florian Mueller says that, in his opinion, the patent shouldn't have been approved at all. I think it should not have been granted. The patent office made a huge mistake. The patent's wording from the start is deliberately vague. Storage medium, information processing system, information processing apparatus, and game processing method could describe virtually anything, from AI systems to self-driving car controllers and even word processors. And there is the patent screenshot here that says, storage medium, information processing system, information processing apparatus, and game processing method. And its applicants are Nintendo as well as the Pokemon Company. While Claim 1 describes a non-transitory computer-readable medium storing a game program, Mueller refers to this as boilerplate, an attempt by Nintendo to make the patent appear as a technical invention. Simply submitting patent this game rule would have been rejected outright, so this language is deliberately obfuscated. For the patent to hold legal weight, each claim, starting with Claim 1 and continuing onward, must be infringed. There is no dispute over the so-called storage medium. Any video game running on a console or PC obviously satisfies that element, making the first few words essentially meaningless. you can revoke and invalidate patents, it should be revoked and invalidated. The meat of the patent lies in the broader gameplay mechanics, particularly the system for summoning characters to battle. If you look at how broad the language is, this is not limited to Pokemon. For example, performing control of moving a player character on a field in a virtual space based on a movement operation input. Look at how vague that is! Like, that would apply to so many things! Like in Final Fantasy, you can summon things to fight alongside you. Are you kidding me? Sad that people are supporting Nintendo doing this because of some twisted hatred against Palworld. I don't know why you would hate Palworld. Like, even if you're like some die-hard Pokemon fanboy, right? Like, I fucking love Pokemon, man. But Pokemon has been stagnating for way too long. They don't listen to people about what we would like to see in games. They don't invent anything new anymore. They just do gacha slop to try and take more money from people. And it took Palworld existing to make them innovate anything. And I would have been fine if all they did was look at Palworld and see how successful it was and be like, oh shit, maybe we've been complacent for too long. But instead of doing that and accepting that they're gonna have competition for once in their fucking lives, they decided to use every apparatus of legal, like, lawfare kind of shit to get Palworld cut down. It's disgusting and it's grody. A lot of the Pokemon fanbase are basically cultist. It's so weird. The real focus is on sub-characters summoned in response to player input. A sub-character is distinct from the player character. Basically, the player presses a button or moves a joystick and the sub-character appears. The patent even covers positioning relative to enemy characters. The combination of summoning, sub-characters, and positioning is what gives the patent its potential reach. Oh, I'm glad they brought it up too. This means mechanics in games like Final Fantasy could technically fall under the patent, even though they predate Pokemon-style summons. They very much do. Pokemon was nowhere near the first. Fucking Shin Megami Tensei was around before Pokemon. Legal interpretation, Mueller notes, could be messy. Courts might decide what counts as a sub-character or a field, and whether a 2D grid could qualify as a virtual space. Even if a game is technically different, it might still risk infringement, he warns. Yet despite the patent's broad wording, Mueller believes the actual risk to developers is limited. Palworld will continue mostly unaffected. The broad enforcement scenario that people fear probably won't materialize, he says. Awareness, he stresses, is key. Monitoring patents and understanding prior art can help developers navigate this potential minefield. Even if the patent wouldn't survive a court challenge, it has immediate consequences. Litigation is expensive. Even if you're right, and even if you're confident you would win, you still have to spend millions fighting the lawsuit. And for smaller developers, that's not an option. They'd rather settle or change their game design than face that risk. In other words, Nintendo probably already knows it won't win every lawsuit, but the existence of the patent alone will deter competition. So the question remains, how did such a broad gameplay mechanic, one that is within hundreds of other games, get through the USPTO without question? That is a good question. And also, yeah, Nintendo is just using fucking bully tactics here. Because they count on people being like, I can't fight against Nintendo money, so I might as well just not. That's a literal fear tactic. The examiner probably didn't fully consider the scope of prior art in video games, or didn't fully grasp how common summoning mechanics already were. Well, then that sounds like that examiner is not fully competent for their position, are they not? If they're going to pass something like this that they have no knowledge about, they are not fit to be able to pass these kinds of things. Like, even if you don't have the knowledge innately, you should do research on it, should you not? Patent law wasn't originally designed with video games in mind. A lot of the terminology and concepts come from hardware or software patents. So when game companies file something like this, it can slip through the cracks because the examiner doesn't have deep gaming knowledge. Nintendo's US patent has implications far beyond domestic developers. The moment a game enters the US market, it becomes subject to US patent law, regardless of whether the developer is based in Europe, China, or Japan. Smaller devs are the most vulnerable, and big companies like Sony or Microsoft can defend themselves with their own patent portfolios, but startups and indie studios face a chilling effect. The future of an increasing litigious gaming industry. This is search query, hits, reference number, timestamp. I don't know what I'm looking at here. It's just a lot of fucking acronyms. The key to maintaining, Mueller pointed out search documentation from the patent filing showing that in a search for prior art, the USPTO didn't even Google and simply searched prior patents. Again, that sounds like this person probably isn't serious enough to take their position seriously. The key to maintaining a healthy competitive industry, Mueller emphasizes, is awareness and proactive defense. Other developers should actively monitor major players, submit prior art to patent offices, and challenge overly broad patents. That's how you prevent these issues from becoming standard practice. For gamers, he advises staying informed and understanding of changes in titles like Palworld, which may be driven more by litigation than design, lest we forget the not too well received update that broke the game at first. In the end, Mueller's point is clear. Broad patents can provide leverage, but they don't have to hold back innovation in gaming, so long as the industry remains informed when it comes to cases like this. The Nintendo versus Pocket Pair case will continue to be closely watched, especially if Nintendo decides to pursue it in the US. Whether this latest patent will actually be used in legal action is still up in the air. And if it is used instead of revoked for being fucking ridiculous, hopefully it can be defeated in court, because again, it's way too fucking vague. It's very clearly Nintendo trying to weaponize game mechanics to choke out competition, and that's not good. That's not good for like a healthy market or for the consumer base. It's Final Fantasy composer shares concern about stagnation in game music. Frankly speaking, there's less weird things now. I believe directors and producers hold too much power in their hands even when it comes to the music. As reported by Automation, iconic video game composer Nobuo Uematsu, best known for his work on the Final Fantasy series, has recently given his take on the state of video game music. In an interview with Japanese outlet Real Sound, Uematsu commented on where the industry is now, particularly concern about creative freedom for composers being stifled. I won't go so far as to call it stagnation. Yeah, title! But I believe directors and producers hold too much power in their hands when it comes even to the music, said Uematsu according to Automation's translation. Even now, game composers aren't in a position to speak their opinion freely. No matter how much musical knowledge or technical skills they possess, they're still in a position where it's difficult to speak their mind. There are almost no game producers who are well-versed in worldwide entertainment and are familiar with a wide variety of musical genres, so anything goes for them as long as you make it sound like a John Williams movie soundtrack. And he has a good point. How many tracks from video games in the last 10 years can you remember the name of the song of? How many of those tracks can stand out in your mind as something as unique as, say, Sephiroth's theme, right? Like when you hear the beginning notes of something like Sephiroth's theme or Genova's theme or any of like the older video game instrumentals, you can immediately either remember the name of the song or the character associated with it, or at least the game associated with it. Now, if people were to play soundtracks from like Final Fantasy 16 or any of the other like new AAA role-playing game stuff, Forspoken probably included in that, I don't think I'd be able to tell the difference between them. We've been to Distant Worlds, and One Winged Angel was such a highlight that the conductor turned to the audience and asked us to yell Sephiroth as loud as we could. That's cute as fuck. That's cute as fuck. Chrono Cross has amazing music. Michael Garrod Kelly makes fantastic music. Yeah. I think the only example I can think of recently is potentially Expedition 33. I haven't finished playing it, so I don't know like what any of the other like late game music is like. Usually they don't plop their dick out on the table in the beginning. They have like the real iconic shit later. You have to respectfully call the use of 16 a bad example because the music in that game is amazing. I mean, it's still, Final Fantasy's still gonna have better music than most other games, but it was just the first thing to pop into my head. I guess I could use Final Fantasy 13 as a better example. I can't remember fucking anything from that forgettable hallway simulator. Except for the little chocobo that lives in the guy's afro. It's like the only thing I can remember. Uematsu compared the situation to the game music industry back in the NES era of the 80s. Back then, few composers had their eye on making music for games, but that has changed dramatically over the course of Uematsu's career. According to Uematsu, the industry has gone from giving game composers little attention to stifling composers' creativity, or pushing them towards a narrow type of sound, often a John Williams style. As a result of that, Uematsu added that, frankly speaking, there's less weird things now. And I think this is probably why Expedition 33's soundtrack stands out quite as much as it does, right? Because we just don't hear too many things that differentiate themselves from large games anymore. And Expedition 33 isn't even a AAA game, right? It's again proving his point that the only examples we can really think of in current year are like indie studios or AA games. There's a severe lack of talent in the mainstream, and you think you remember someone attributing it to being easier to make it as an indie now, with tools and many devs being able to reach their market as a content creator. Yeah, that seems pretty great for smaller creators. Uematsu didn't seem too pessimistic about the future of game music, though. He's an avid fan of Elton John and cited the pop rock artist's ability to create great music while still prioritizing commercial success. He sees this as evidence that it's possible to work with the demands of game directors and producers without compromising creativity. With that said, Uematsu seems to be exclusively addressing professional development in this interview, and likely has Japanese developers in mind. This makes sense given it's the area of the industry he operates in, but we'd be remiss if we didn't mention how much good, weird music there still is in games, particularly independent ones. And again, like when I asked you guys, pretty much all of the examples we were bringing up were like independent games. Pizza Tower mentioned! Sega-style beats, Hollow Knight's Haunting Strings, the slick rock tracks in Hades, and Scald against the Black Priories, a DOS soundtrack, I can't read the sentence. Scald against the Black Priories DOS sound card inflected fantasy score. I have no idea what any of those words I just read mean. All spring to mind. Uematsu suggested aspiring game composers keep trying new things, saying, if you make the same stuff as John Williams and grow complacent with that, you'll get nothing more from it. Now, what if someone put a bit of techno in there? What kind of sound would it become then? I believe that would be a good way to approach music. Yeah, fucking just try different shit, man. Be experimental. Bring music like Halo and Skyrim back. DOS sound card is very retro. She can't into DOS. I cannot. Black Raven, you got Grandma, Alien Infestation, Peaceful Sleep, Fortress of Lies, so many bangers. Man. True, put your penis on it, No! Not like that! Uematsu's the Beethoven of game composition. The only, like, names that I can remember, and again, with my shitty fucking ass memory, right? The fact that I can remember Nobuo Uematsu and, oh god, there's always one other composer I remember the name of. Yasunori Mitsuda. Those are the two names that even my, like, fucking Alzheimer's riddled brain can remember, you know?